Ladies and gentlemen, folks, all sorts of creatures in this universe, welcome back to another episode of The Sleepy Reader. Now, today I thought we'd do something a bit different, um, and we're going to be talking about a true crime case about a boy named George Stinney, or Stinney, I believe. I'm just gonna hold up. Let me just gonna George Stinney pronunciation.
George Stinney.
George Stinney. Okay. Yeah, I don't want to be mispronouncing that. This is gonna be a very unedited episode. Probably not gonna edit it at all. But if you enjoy sleeping to true crime, this new series might be something for you. Anyway, yeah, I'm just gonna be reading straight from his Wikipedia page because I find that has the most information and quite simple to access. But of course, before anything, this episode will involve murder, sexual assault, and some other difficult things to hear. So if you are, yeah, if you don't want to hear that, you have time to leave. For those of you who are going to sleep, good night. I hope you don't go to sleep though, because this is quite a serious topic, and yeah, but hey, I'm not you. You can do whatever you want. I just want to talk about this boy because his case is very, very disturbing and very sad and somber, and I don't know, just felt like talking about it. Anyway, if you are going to drift off, get comfy, get a warm blanket, and enjoy. George Junius Stinney Jr., born October 21st, 1929, dead June 16th, 1944, was an African-American boy who was wrongfully executed at the age of 14 after being convicted during an unfair trial for the murder of two white girls. These girls were 11-year-old Betty June Binnicker, who was born December 9th, 1932, and March 22nd, 1944, and 8-year-old Mary Emma Thames, March 14th, 1936, and March 22, 1944. Now, this murder happened in his hometown of Alcolu, South Carolina. He was tried, convicted, and sentenced to death on a single day in April 1944, then executed by the electric chair on June 16th, 1944, after the governor, Olin D. Johnston, refused to grant him clemency. Before I go on, just that's already a horrible start. Yeah, and it's just gonna get sadder. A re-examination of Stinney's case began in 2004, and several individuals and the Northeastern University School of Law sought a judicial review. Stinney's murder conviction was vacated in 2014, with a South Carolina court ruling that he had not received a fair trial and was thus wrongfully executed. That's 70 years. He was killed in 1944, and 70 years later, in 2014, only then did they agree that he had an unfair trial. Stinney is the youngest American with an exact birthday confirmed to be both sentenced to death and executed in the 20th century. So, some background of him. In 1944, George Stinney, he was about 5 feet 1 inch or 154 centimeters. He weighed about 90 to 95 pounds. He lived in a small house with a chicken coop in his hometown of Alcolu, South Carolina, with his father, George Junior Stinney, and his mother, Ame Brown Stinney. His brother, Charles Stinney, who was 12, and sisters, Catherine Stinney, who was 10, and Ame Stinney Ruffner, who was 7. Stinney's father worked at the town sawmill, and the family resided in company housing. Alcali was a small working-class mill town. It was a white and black neighborhoods were separated by railroad tracks, which was quite common for small southern towns of the time. And given segregated schools and churches for white and black residents, there was very limited interaction between white and blacks. Um, on March 23rd, 1944, the bodies of Betty June Binnicker and Mary Emma Thames were found in a ditch on the African American side of Alcolu after the girls failed to return home the night before. Stinney's father assisted in the search. The girls had been beaten with a weapon variously reported as a piece of blunt metal or railroad spike, which makes sense according to where it was. Um, Binnicker and Thames, the girls who were killed, both suffered severe blunt force trauma, resulting in penetration of both girls' skulls. According to a report by the medical examiner, these wounds have been inflicted, or quote unquote, inflicted by a blunt instrument with a round head about the size of a hammer. The medical examiner reported no evidence of sexual assault to the younger girl, though the genitalia of the older girl was slightly bruised, meaning that it, that it likely may have happened. Um, the girls, they were last seen riding their bicycles looking for some flowers. Um, they passed by the Stinney's property and they stopped to ask Stinney and his sister, Ame, if they knew where to find maypops, which was the local name for passion flowers. And according to Ame, she was with Stinney at the time, and the police later established the murders occurred. So she was with him when the murder supposedly occurred, or did occur. According to an article by the Wire Services on March 24th, 1944, the sheriff announced the arrest of George Junius and stated that the boy confessed and led officers to a quote-unquote hidden piece of iron. During the end of his comedy investigation, George and his older half-brother John were arrested on suspicion of murdering the girls. John was released by police, but George was held in custody. He was not allowed to see his parents until after the trial and conviction. According to a handwritten statement, his arresting officer was H.S. Newman, who was a Clarendon County deputy, who stated, quote unquote, "I arrested a boy by the name of George Stinney. He then made a confession and told me where to find the piece of iron. About 15 inches, where he said he put it in a ditch about 6 feet from the bicycle." In 1995, Stinney's 7th grade teacher, W.L. Hamilton, who was a black man, spoke in an interview with the Sumter item about George. Hamilton, the teacher, recounted, quote unquote, "I remember the day he killed those children. He got into a fight with a girl at school who was his neighbor. In those days, you didn't have to worry about children carrying guns and knives to school, but George carried a little knife, and he scratched this child with his knife. I took him outside, and we went for a little walk, and I talked to him. We went back to school in a submissive way. He begged for the child's pardon." Stinney's sister, Ame Ruffner, denied those allegations and contacted Hamilton after it was published. Ame stated, "I asked him why he would say something like that," which was what she said. He told me someone paid him to say it. I don't know who paid him, but his exact words were, "because they paid me." Hamilton, the teacher, died just shortly after the interview was published. Following Stinney's trial, his father was fired from his job at the local sawmill, and the Stinney family had to immediately vacate their company housing. The family feared for their safety. Stinney's parents did not see him again for the trial, and he had no support during his 81-day confinement and trial. He was detained at a jail in Colombia, uh, 50 miles or 80 kilometers from Alcalá, due to the risk of lynching. Stinney was interrogated alone, without a counsel or even his parents. And although uh, the Sixth Amendment guarantees legal counsel, this was not routinely observed until the United States Supreme Court 1963 ruling in the Gideon v. Wainwright case, which explicitly required representation through the course of criminal proceedings. Um, the entire proceeding against George Stinney, including jury selection, took place on April 24, 1944. Stinney's court-appointed counsel was Charles Plowden, a tax commissioner campaigning for election to local office. Plowden did not challenge the three police officers who testified that Stinney confessed to the two murders, nor did he try and defend Stinney either. He also did not challenge the prosecution's presentation of two differing versions of Stinney's verbal confession. In one version, Stinney was attacked by the girls after he tried to help one girl who had fallen in the ditch, and he killed them in self-defense. And in another version, he had followed the girls, first attacking Mary Emma and then Betty June. There's no written record of Stinney's confession apart from the Deputy Newman's statement. Other than the testimony of the three police officers at trial, prosecutors called three witnesses. Reverend Francis Baxton, who would discover the bodies of the two girls, and the two doctors who performed the post-mortem examination. This court allowed discussion of the possibility of rape due to the bruising on Binnicker's genitalia. Stinney's counsel did not call any witnesses. They didn't call any witnesses. They didn't cross-examine the witnesses, and offered little or no defense. This entire presentation lasted about 2.5 hours. More than 1,000 white Americans crowded the courtroom, but no black Americans were allowed. As was typical at the time, Stinney was tried before an all-white jury in 1944. Most African Americans in the South were disenfranchised and therefore not present on the rolls of those available to serve on juries. After deliberating for less than 10 minutes, the jury found Stinney guilty of murder. 10 minutes. Judge Philip Haystone sentenced Stinney to death by electrocution. There's no transcript of the trial, and no appeal was filed by Stinney's counsel. Stinney's family, churches, and the NAACP, which stands for the National Association for the Advancement of Colored People, appealed to Governor Olin D. Johnston for clemency, which is, it's basically a pardon in which the government decision to allow a person to be relieved of some or all the legal consequences, which means he likely would not have been, executed. Given the age of the boy, most of the pleas for the clemency came from a white woman living in South Carolina. There's no citation about that, but yeah. So, some pleas from whites came with affirmations of white supremacy, but discussed over the prospect of someone so young being executed, because he was just 14. Others urged the governor to let the execution proceed, which he did. He visited George Stinney in the death house 2 days before his execution on June 14th. Johnston wrote a response to one appeal for clemency, stating, quote unquote, I have just talked with the officer who made the arrest in this case. It may be interesting for you to know that Stinney killed the smaller girl to rape the larger one. Then he killed the larger girl and raped her dead body. 20 minutes later, he returned and attempted to rape her again, but her body was too cold. All of this he admitted himself, quote unquote. It was reported that these were merely rumors and Johnston's claims were not corroborated by the girl's autopsies. And between the time of Stinney's arrest and his execution, his parents were only allowed to see him once after the trial, when he was held in the Columbia penitentiary under the threat of lynching. They were not allowed to see him any other time. So I mean, Stinney, a 14-year-old boy, was put in imprisoned and couldn't see his parents. Um, an execution of a child as young as 14 was virtually unheard of in the United States history. Even for black children in the Jim Crow South, who were convicted of murdering and raping white victims. Many sources say that Stinney was the youngest person executed in the US in the 20th century. However, it may be incorrect. In the little-known 1915 case, a black boy named Joe Parsons was executed for the rape of an 8-year-old white girl, and he was aged between 12 and 15 in Georgia. Georgia was the official state. Execution registry states that Parsons was 14, but a mercy petition claimed that he was 14, and a newspaper in Philadelphia claimed that Parsons was 13, and a Kentucky newspaper stated that he was no older than 14. So, just a bunch of conflicting statements. And in 1986, Los Angeles Times article that various 1915 newspaper accounts listed his age from 12 to 15 with a weight of 65 pounds, indicating he was likely closer to the former age. Sources from 1915 claim that there was absolutely no doubt about Parsons' guilt. The state execution registry claims that Parsons' crime was so bad that Parsons' father, his own father, supported his execution, and the Kentucky newspaper claimed that Parsons had admitted to his crime and was ready to die. I might make a video on that case if, yeah. Um, Anyways, during the execution, Stinney was executed on Friday, June 16th, 1944, at 7:30 a.m. He was prepared for execution by electric chair. He was too small, and he was way too small for the chair, so they used a Bible as a booster seat. He was then restrained by his arms, legs, and body to the chair. An officer asked Stinney if he had any last words to say before the execution took place, but he only shook his head and said, quote unquote, "No, sir." The executioner pulled a strap from the chair and placed it over Stinney's mouth, causing him to break into tears, and he then placed a face mask over his face, which did not fit him, as he continued sobbing. When the lethal electricity was applied, the mask covering slipped off, revealing all the tears streaming down Stinney's face. The perception was later contested by Terry Evans, the niece of Mary Emma Thames' mother. Lula May, Terry's uncle, Clyde Barnes, witnessed the execution. Barnes told Evans' father what he saw during the execution, which was then relayed to her years later. His father stated that Barnes said it was just a rumor that the hood had slipped away, and they did not put a stack of books under him. Stinney, so that's what they quote unquote say. Stinney was buried in an unmarked grave at Calvary Baptist Church Cemetery in Lee County of South Carolina. So, being 14, he was one of the young, might be one of the youngest or the youngest person ever executed in the 20th century in America. They didn't even give him a marked grave. Um, there's quite a lot about the reopening of the case, so say that. In 2004, George Fiverson, a local historian who grew up in Alcalá, started researching the case after reading a newspaper article about it. His work gained the attention of South Carolina lawyers Steve McKenzie and Matt Burgess. In addition, Ray Brown, attorney James Moon, and others contributed countless hours of research and review of historical documents and found witnesses and evidence to assist in exonerating Stinney. Among those who aided the case were the Civil Rights and Restorative Justice Project, or the CRRJ, at the Northeastern University School of Law, which filed an amicus brief with the court in 2014. Now, an amicus brief is um, an individual organization that is, well, the definition is just an individual organization that is not a party to a legal case, but that is permitted to assist the court in offering information or insight or expertise or anything bearing on the issues in that case. So it's basically just, even though they weren't involved in the case, they have been given information, or they have been given permission to give information. Fiverson and the pro bono lawyers first sought relief through the Pardon and Parole Board of South Carolina. Mackenzie and Burgess, along with attorney Roy Chandler representing Stinney's family, filed a motion for a new trial on October 25th, 2014. There's quite a few, this team, if we can get this case reopened, we can go to the judge and say there wasn't any reason to convict the child, there was no evidence to present to jury, there's no transcript, this case needs to be reopened. This is an injustice that needs to be opened. I'm pretty optimistic that if we can get the witnesses we need to come forward, we will be successful in court. We hopefully have a witness that's going to say that's non-family, non-relative witness, who is going to be able to tie all this in and say that they were basically an alibi witness and they were there with Mr. Stinney and this did not occur. Fiverson stated in interviews there had been a person that has been named as being the culprit who is now deceased, and it was said by the family that there was a deathbed confession. Fiverson said the rumored culprit came out from a well-known prominent white family. Member or members of the family had served on initial coroner's inquest jury, which had recommended that Stinney be prosecuted. Basically, just members of the family served on the initial coroner's request, or just the original jury, which recommended that Stinney be prosecuted. And yeah. The CRRJ said there is compelling evidence that George Stinney was innocent of the crimes for which he was executed in 1944. The prosecutor relied almost exclusively on one piece of evidence to obtain a conviction in the capital case. The unrecorded, unsigned confession of a 14-year-old boy who was deprived of counsel and parental guidance, and whose defense lawyer shockingly failed to call exculpating witnesses or to preserve his right of appeal. New evidence in the court hearing in January 2014 included testimony by Stinney's siblings that he was with them at the time of the murders, in addition to an affidavit, which is a written statement made by an affiant or a deponent under the oath of affirmation, which is administered by a person who is authorized to do so by law. This was introduced from the Reverend Francis Baxton, who found the girls and pulled them from the water-filled ditch in his statement. In the statement, he records there was not as much blood around or in the ditch, suggesting that they may have been killed elsewhere and moved. Wilford Johnny Hunter, who was in prison with Stinney, testified that the teenager told him he had been made to confess and always maintained his innocence. The solicitor for the state of South Carolina, who argued for the state against exoneration, was Ernest A. Finney III. He is the son of Ernest A. Finney Jr., who was appointed as South Carolina's first African American state Supreme Court justice since Reconstruction. Rather than approving a new trial on December 16, 2014, the Circuit Court, Judge Carmen Mullen, vacated Stinney's conviction. She ruled that he had not received a fair trial, and he was not effectively defended, and his Sixth Amendment rights had been violated. The ruling was a rare use of the legal remedy of coram nobis, um, which is a legal order allowing the court to correct its original judgment upon discovering of a fundamental error that did not appear in the recordings um, or the recorded original judgment proceedings, and that would have been prevented the judgment from being pronounced. It's basically just allowing to edit the case um, because of conflicting information. Judge Mullen ruled that his confession was likely coerced, coerced, and thus inadmissible. She also found that the execution of a 14-year-old constituted cruel and unusual punishment, and that his attorney failed to call exculpating that the attorney failed to call exculpating witnesses or to preserve his right of appeal. Mullen confined her judgment to the process of prosecution, noting that Stinney may have committed this crime. With reference to the legal process, Mullen wrote, quote unquote, "No one can justify a 14-year-old child tried and convicted and executed in some 80 days, concluding that in essence not much was done for the child when his life lay in the balance." Yeah, that is quite a bit. There's just three more paragraphs. This was the reaction of Binnicker and Thames' relatives. While Stinney's family and civil rights advocates celebrated the overturning of Stinney's conviction, relatives of both Betty Binnicker and Mary Thames expressed disappointment at the court's ruling. They said that although they acknowledged Stinney's execution at the age of 14 is controversial, they never doubted his guilt. Binnicker's niece claimed she and her family had extensively researched the case and argues the people who just read these articles in the newspaper don't know the truth. She alleges in the early 1990s a police officer who had arrested Stinney had contacted her and said, "Don't you ever believe that boy didn't kill your aunt?" Don't you ever believe that boy didn't kill your aunt, was what the police officer said. These family members contend that the claims of a deathbed confession from an individual confessing to the girl's murders have never been substantiated. Commenting on the public opinion regarding Stinney's case, she said that the case had always been one-sided and that Stinney has been incorrectly portrayed as a poor, pitiful little black boy. At the time, another niece of Binnicker, while remaining convicted of Stinney's guilt, agreed that Stinney did not receive a fair trial and that he should not have received the death penalty, adding that she felt bad for Stinney and his family and that she hoped they eventually would find peace. A childhood acquaintance of Binnicker also stated, "I'm sorry that they electrocuted him. I wish they had just sent him to prison." An alternate, sus- an alternate suspect, since Stinney's exoneration, George Washington Burke Jr. He was born 1917, died 1947. He was the son of a wealthy white businessman, George Burke Sr., and has been the subject of speculation as a possible suspect for the murders. Um, George Burke Jr. died 2 or 3 years after the murders of the girls in 1947 at age 29. Stinney's mother had worked for the Burke family for a brief period. Stinney's sister called that her mother had once come home saying that Burke Sr. had made advances to her, and that their father had warned their mother to no longer go back. Stinney's sister claimed that to have heard that the Burke boys had framed Stinney because their mother didn't want to give it up, quote unquote. Um, Belk Sr. conducted an initial search for the girls and was the owner of the territory behind Green Hill Baptist Church where the girls' bodies were found. He was also the foreman and the grand jury that indicated Stinney and had been accused of helping steer the blame off his own son and onto Stinney. Two elderly women in Alcaloo recalled that Belk Jr. was known as a womanizer and for committing theft and getting away with it. Sonia Edie Williamson, a white Alcaloo resident, grew close. She grew close with Stinney's sister, investigated the court case, and according to her, George Belk Jr.'s son, Wayne Belk, told her that his grandmother had told him that his father had picked the girls up in his lumber truck by his grandmother's house on the day of the girls' murder in 2017. Um, just on the day of the girls' murder, sorry. In 2017, Wayne Belk denied saying this, and he remained convicted of Stinney's guilt. Stinney's sister had previously recalled that after the two girls had asked about maypop flowers, a lumber truck drove down the road. Lawyers for the Stinney family had stated that there had been rumors of a deathbed confession to the murders by a member of a prominent white family, however, it was never proven. So yeah, that was quite a lot of information. Um, George Stinney was and is one of the saddest cases I've ever read about. Um, yeah, I mean, at 14, wrongfully convicted for murder. I mean, at 14, being blamed for something that you didn't do is a really bad feeling. And I can't even begin to imagine what Stinney must have felt being blamed for the ending of two lives in at just 14 and not given a fair chance at all. I think that's absolutely ridiculous and it's incredibly sad. And my condolences goes out to both families and everybody involved in this horrific case. There are photos of his mugshot and him as a young child. Um, I won't show them because I don't know. I don't think me showing you these photos have much to benefit with this entire case, and also most of you are likely asleep. Um, but this case is horrific and is a key and is a really big example to, or a really big reference in the debate over the use of death penalty in the United States, especially in arguments against the death penalty, due to Stinney being innocent and wrongfully executed. I think overall this case is absolutely horrible and a sickening case. And yeah. I don't really have much else to say other than my heart goes out to all of those involved in this horrific case. And my heart goes out to Stinney and the two girls as well. All of their lives were cut too short, unfortunately. Yeah. Well, that was George Stinney, a horrific case, and more a saddening case. And yeah. I know this is a bit of a, branch from my usual, I guess, what I usually do, just read stuff, read fiction books. But I think it's also important to talk about these real cases that affect real people. Yeah. Anyway. Yeah. Well, good night to you all, and thank you for listening.